Everyone. Our next topic is a catastrophic impairment update with Andrew Rudder and Brenda Power Ahmed. Let me just introduce Andrew to you. Andrew is the principal of his own law firm, Rudder Law Group. His practice focuses on claims involving severe injury and catastrophic impairment in the claims of motor vehicle accidents, slip and fall, assault, and disability claims. Andrew is a regular attendee at the Superior Court of Justice and tribunals, as well as appellate courts. He speaks regularly on the issue of catastrophic impairment and has actually written a book called Catastrophic Impairment Law in Canada.
Before I begin, I just want to thank Mr. Winepearl and Mr. Sullivan for inviting me here, as well as the Hamilton Law Association, too. It's an honor to be here amongst this distinguished panel of guests. So today I want to discuss the deep dive strategic approach I use in one of my unreported CAT cases. So I won't summarize every post-June 1st, 2016 CAT cases. I've already done that for you in my report that hopefully you have a copy of. I found that the crux of the vast majority of the disputes and the reported decisions revolve around figuring out the intention of the Ontario legislature to use specific words or language in the CAT sections of the schedule within the broader context of the legislative scheme of the Insurance Act. So for example, in the case ZR and AR and Certis Direct Insurance Company, the dispute was whether or not the intention of the legislature to use the word with to denote a temporal association or connection between a child's admission to a hospital on an inpatient basis and a positive finding of intracranial pathology. So I thought you'd get more value from me discussing my strategic approach to obtaining a CAT designation when the primary point of contention is an interpretation issue. So I'm going to focus today on a new automatic CAT definition for children, where the crux of the dispute was figuring out the intention of the Ontario legislature's use of a superintendent's guideline. I want to show you the deep dive strategic approach to statutory interpretation I used to successfully overturn an insurer's denial of an automatic CAT designation to my client, which increased her policy limits to $1 million, as well as persuade the Financial Services Regulatory Authority of Ontario to amend the now old superintendent's guideline. However, I first want to mention the significant amendments concerning TBIs. So one of the big amendments was the removal of the Glasgow Coma Scale test as a means to obtain an automatic CAT designation with a GCS score of 9 or less. Also, more objective scientific and evidence-based criteria were added, such as the King's Outcome Scale for childhood head injury. That's one of the ways to determine if a child qualifies for a CAT brain injury. And lastly, both children and adults are no longer assessed under the same section for the purposes of the CAT analysis. Separate provisions in the schedule were created specifically for children with brain injuries, granting them CAT status automatically if the required criteria are met. So those separate provisions are set out in section 3.115 of the schedule. So as you can see, it contains 5 disjunctive parts or subparagraphs, which are applicable at different times. For example, the first and second subparagraphs are applicable at hospitalization when the child is admitted as an inpatient. I'll be focusing on an interpretation issue concerning the first subparagraph, which introduces the new automatic CAT designation. Here is a similar fact scenario to one of my CAT cases. So my client was a 17-year-old Indigenous girl who was a passenger in a vehicle traveling at 100 kilometers an hour in the 6 nations of the Grand River Reserve. The driver lost control of the vehicle and crashed into a tree, which sent my client head first through the windshield and causing severe head trauma. The Brantford General Hospital was close by, so the paramedics brought her there, where she was admitted as an inpatient. She also sustained multiple fractures to her spine, right elbow, and right hand. This prompted the physicians to transfer her to the Hamilton Health Sciences, which is a hospital network comprising 7 unique hospitals. She was admitted as an inpatient to the Hamilton General Hospital, which is a level 1 trauma center. The radiologist used recognized brain diagnostic technology to conduct neuroimaging tests, which revealed evidence of acute intracranial pathology. However, despite her head trauma, she wasn't transferred to the Regional Rehabilitation Center, which treats TBIs. her multiple fractures triggered inpatient protocols, so she was transferred to the 6 South Surgical Trauma Center in the Hamilton General Hospital, so orthopedic surgeons could perform immediate surgery on her spine, elbow, and hand. So in order for my 17-year-old client to be granted an automatic CAT designation, she had to satisfy 3 criteria: inpatient admission to a public hospital in a guideline, positive findings of intracranial pathology, and the use of medically recognized brain diagnostic technology. I initially assumed my client satisfied the 3 criteria. I mean, she was admitted as an inpatient at Hamilton General Hospital, and medically recognized brain diagnostic technology confirmed that she had positive findings of intracranial pathology. So I got a medical opinion from a pediatric neuropsychologist with a PhD. The doctor arrived at the same conclusion as I and submitted an OCF-19 form to the insurance company. The insurer retained a reputable neurologist who also arrived at the same conclusion as us. So, case closed, right? Well, no, not so fast. If you take a closer look at the first criterion to be satisfied, it states admission on an inpatient basis to a public hospital in a guideline, which begs the question, what guideline? The guideline that's being referred to is the June 2016 Catastrophic Impairment Public Hospitals Guideline, Superintendent of Financial Services Guideline number 01/16. The Superintendent's Guideline has a list of 12 public hospitals for which inpatient admittance is the first criterion for determining whether an insured child has a TBI and a catastrophic impairment. You can see the 12 hospitals in this slide and which city they're located in. The reason these public hospitals are on the list is because admission of a child as an inpatient to them are deemed to be sensitive indicators and clinical predictors of prolonged recovery and poor outcome. The superintendent's guideline list of 12 public hospitals was essentially taken from the 11 hospitals that the Ministry of Health and Long-Term Care designated as lead trauma hospitals in the early 1990s, which you can see here in this slide. If you compare the 2 lists, you'll notice that the Hamilton Health Sciences was removed and replaced with the Regional Rehabilitation Center and the McMaster's Children's Hospital. In my fact scenario, my client was admitted as an inpatient to the Brantford General Hospital and then the Hamilton General Hospital. However, neither one of them are among the public hospitals listed in the superintendent's guideline. So even though my client met the 2nd and 3rd criteria for sure, and the insurer's retained neurologist concluded that my client met all of the criteria, the insurer still denied my client an automatic CAT designation because they concluded that she didn't satisfy the first criterion. So what do? How do you strategically approach building a comprehensive sound argument to either persuade the insurer to overturn its decision or win at a licensed appeal tribunal if the insurer maintains its denial? Well, I'll show you what I did. So I'm going to take you through my deep dive approach to interpreting a section. First, you got to appeal to common sense. Then you got to apply the modern approach to statutory interpretation. This requires you to know the objectives and purposes of insurance law and the intention of the Ontario legislature. You got to research precedents on interpreting the section. You got to examine source documents like medical journals and the American Medical Association guidelines referenced in the section, dictionaries, and the definition section of the schedule. So the first thing I do is approach issues like this from a common sense perspective. I ask myself, if I wasn't a lawyer and someone told me about this problem on the streets, what would be my prima facie response? After I assess the issue myself, I also ask other people, such as non-lawyers like my legal assistant, physicians like the pediatric neuropsychologist I consulted for in my case, and healthcare professionals like an occupational therapist like Brenda, who works on a lot of CAT cases. I do this in order to get a different perspective. Non-lawyers also help me grasp the grammatical and ordinary sense of the words of an act I'm trying to interpret as I'm reading in their entire context. When I took this common sense approach, I discovered several common sense observations. So I won't go through all of them, but here's one. If the admission of a child as an inpatient to the level 1 trauma centers on the superintendent's guideline list of public hospitals are sensitive indicators and clinical predictors of prolonged recovery and poor outcome, then why are some level 1 trauma centers on the list and others are excluded? The Hamilton General Hospital is a level 1 trauma center, but it's not on the list. Its equivalent in London is the London Health Sciences Center, which is also a level 1 trauma center, and it is on the list. The next thing I do is apply my common sense observations to the other side's interpretation of the section. I do this because further to the Supreme Court of Canada case Rizzo and Rizzo Shoes Limited, I want to draw out ridiculous, frivolous, unreasonable, inequitable, illogical, or incoherent consequences and things that are incompatible with the intent of the Ontario legislature, which logically follows the other side's interpretation of the same section. So here's an example of how I draw out the absurd consequences using the first common sense observation. If a child is involved in an MVA in London and is admitted as an inpatient to the London Health Sciences Centre with the same positive findings of intracranial pathology as a child admitted as an inpatient to the Hamilton General Hospital, the first child will be granted an automatic CAT designation, but the second child will not? Well, this is absurd because it creates a problem with inconsistent outcomes. This is absurd, inequitable, and incompatible with the intent of the Ontario legislature because a child's automatic CAT designation should be determined by utilizing a medical evidentiary basis to ensure that outcomes of the designation process are fair, reliable, accurate, consistent, and predictable, and not strictly based on the location of the MVA and its close proximity to the public hospitals on the list. After I use this common sense approach, I then start to take a closer look at the rules governing the modern approach to statutory interpretation. So the starting point is the Supreme Court of Canada case, again, Rizzo and Rizzo Shoes Limited. It dealt with the issue of whether the termination of the employment of employees, which was caused by the bankruptcy of an employer, gives rise to a claim in bankruptcy for termination pay and severance pay in accordance with sections 40 and 48 of the Employment Standards Act. So the crux of the issue was the interpretation of the phrase termination by an employer. The Supreme Court of Canada noted that when dealing with benefits conferring legislation, it is appropriate to use a broad and generous approach to interpreting the words of a section and grasp a better understanding of the words through an examination of the entire context of the section in the legislation. It summarized the ideal approach to statutory interpretation as follows, quote, "Today, there is only one principle or approach, namely the words of an act are to be read in their entire context in their grammatical and ordinary sense, harmoniously with the scheme of the act, the object of the act, and the intention of Parliament," end quote. So the takeaway for me was that regarding the interpretation of the guideline in section 3.115I, their words would be read in their entire context and in their grammatical and ordinary sense, harmoniously with the scheme and object of the Insurance Act and the schedule and the intention of the Ontario legislature in a broad and generous manner that best ensures the attainment of the pith and substance of their true spirit, intent, and meaning. I also analyzed the Court of Appeal for Ontario case R Farmers Mutual Insurance Company and Wright. So the primary issue was whether the claimant was involved in an accident as defined in the schedule. The crux of the issue was the interpretation of the phrase insured person. The Ontario Court of Appeal interpreted an insured person as encompassing all persons claiming entitlement to benefits under the schedule, whether or not it is ultimately determined that they are entitled to benefits. In doing so, it emphasized three things. One, the centrality of a statute's purpose. Two, the three factors that must be examined, which are the text or language of the provision, the context in which the language is used, and the purpose of the legislation or statutory scheme in which the language is found. And lastly, the importance of not interpreting words in a provision that is contrary to the legislation's intent and object. So the takeaway was that in order to determine whether the first criterion of the automatic CAT definition is incompatible with both the object and scheme of the Insurance Act and the schedule and the intention of the Ontario legislature, a court would have to adopt a textual, contextual, and purposive approach to interpreting the first criterion of section 3.115I and the superintendent's guideline. I also looked at section 64 sub 1 and 2 of the Legislation Act, because they also provided additional guidance pertaining to the rules of statutory interpretation too. The key takeaway was that the court would also be required to view the Insurance Act and the schedule as remedial and benefits conferring legislation while interpreting section 3.115 in a fair, broad, and liberal manner that best ensures the attainment of their intent and objects. And the rules governing the modern approach to statutory interpretation apply equally to the schedule, which must be read in the context of its enabling act, the Insurance Act. I also analyzed the Supreme Court of Canada case Progressive Homes Limited and Lombard General Insurance Company of Canada, which turned on the issue of insurance policy interpretation. It dealt with the issue of whether the insurer owed a duty to defend claims against the insured. The Supreme Court of Canada noted the fundamental interpretive principle of contra preferentum when the language of a policy is ambiguous and general rules of contract construction fail to resolve the ambiguity. When a court construes a policy contra preferentum, coverage provisions are interpreted broadly and exclusion clauses narrowly. So the key takeaway for me was that if the court is to construe the guideline and schedule contra preferentum, then while interpreting the guideline in section 3.115I of the benefits conferring schedule, it would broadly interpret the coverage component and narrowly interpret the exclusion criterion that's based on non-admittance of an inpatient to one of the public hospitals listed in the superintendent's guideline. The next step further to the Supreme Court of Canada is to ensure that your interpretation is not contrary to the objective and purpose of insurance law and the statutory scheme. So what's the main objective and purpose of insurance law? Well, the starting point is the Supreme Court of Canada case Smith and Cooperators General Insurance Company, which involved questions pertaining to statutory interpretation in the context of limitation periods in Ontario's insurance law. The Supreme Court of Canada recognized that the main objective of insurance law is consumer protection. So the key takeaway was that consumer protection would be strongly considered in interpreting section 3.115I of the schedule. And in doing so, a court would impose bright line boundaries between the permissible, such as the Ontario legislature's intent to improve the accuracy, clarity, predictability, reliability, and validity of the CAT designation process, and the impermissible, such as inequitable discrimination based on geography and absurd or frivolous consequences that are incompatible with the intent of the Ontario legislature, without undue solicitude for particular circumstances, such as a provincial bureaucratic glitch that operates against vulnerable and seriously injured automobile accident victims who are in dire need of early access to the highest tier of accident benefits. I also analyzed this Supreme Court of Canada case, Whitten and Pilot Insurance Company, which primarily dealt with what constitutes a permissible quantum of punitive damages in terms of how the means of arriving at the award are rationally proportionate to the primary purpose of retribution, deterrence, and denunciation. This is, of course, the infamous bad faith case where the jury awarded a little over $300,000 in compensatory damages and $1 million in punitive damages. The Supreme Court of Canada discussed the main purpose of insurance contracts, which is to provide insurers with peace of mind. So the key takeaway was that when deliberating on insurance contract disputes, courts must read in the entire context of the main purposes of insurance law, such as consumer protection and good faith dealing, with the objective of providing peace of mind to vulnerable insureds, such as catastrophically impaired children with severe traumatic brain injuries who experience devastating unforeseen losses and uncertainty on how they're going to pay for the exorbitant future care costs so as to avoid undue stress and hardship. So the next step further to the Supreme Court of Canada is to ensure that your interpretation is not contrary with the intention of the Ontario legislature. Well, how do you learn about the Ontario legislature's intention? Well, I carefully reviewed the Insurance Act and learned that every 3 years, the superintendent was required to submit a report to the Minister of Finance containing the superintendent's recommendations for amendments to the regulations. So in 2011, the superintendent retained Dr. Per Coate to chair an expert medical panel for the purpose of making amendments to the definition of catastrophic impairment. This ultimately led to the superintendent's report on a definition of catastrophic impairment in the Statutory Accident and Benefits Schedule and its recommendations to the Minister of Finance. It was this report that was submitted to the Lieutenant Governor and Council and then went before the Legislative Assembly of Ontario, which influenced the content of Ontario Regulation 25115 and ultimately amended the schedule on June 1st, 2016. As such, this report provides great insight into and aids in discerning the intention of the Ontario legislature for the purposes of a statutory interpretation analysis. So in my CAT case, I reviewed the superintendent's report to first identify macro objectives, which are the overarching broader goals that support my interpretation of the guideline in section 3.115I. I do this because in the spirit of a contextual analysis, the macro objectives give context for more specific micro objectives of the Ontario legislature. Lastly, I identified the micro objectives and the purpose of the changes in CAT determinations for vulnerable children with severe TBIs in particular. All of this provided me with a better understanding of the underlying rationale for and the intention of the Ontario legislature. I then examined the original recommendations made by the panel of medical experts for the criteria of an automatic CAT designation for children, and then I compared and contrasted to the language being used in the current section 3.115I. So you can see in the slide that by comparing the original recommendation on the left and the current criteria on the right, it was the intention of the Ontario legislature to grant an automatic CAT designation to a child who sustained a TBI if the child was admitted as an inpatient to a level 1 trauma center, coupled with positive findings of intracranial pathology. In my scenario, my client was admitted as an inpatient to the Hamilton General Hospital, which is a level 1 trauma center, even though it wasn't on the list of 12 public hospitals. So in order to further understand the intent of the Ontario legislature, I also look at the source documents that they reference. For example, section 3.115 of the schedule references a medical journal article written by Dr. Crouchman called the Practical Outcome Scale for Pediatric Head Injury. This article introduces the new measurement tool called the King's Outcome Scale for Childhood Head Injury, which the Ontario legislature adopted to improve the accuracy, validity, reliability, and predictive ability of measuring a child's level of neurological function for catastrophic impairment determinations. So you want to read the article to discover the contextual medical foundation for which the Ontario legislature is building its criteria on for an automatic CAT designation for children with severe TBIs. If you read the article, you learn that Dr. Crouchman refined the Cauchy scale by obtaining statistical data from observing inpatient management and outpatient follow-up of approximately 200 head-injured children admitted to the pediatric wards of King's College Hospital and a pediatric neurosurgical unit over the period 1990 to 1997. So I wanted to see if there were any findings from the study that supported my interpretation and contradicted the opposition's interpretation. So for example, Dr. Crouchman found that 90% of the children admitted as an inpatient to the pediatric wards of the King's College Hospital with abnormal intracerebral radiological findings on computed tomography had severe TBIs. This statistical data supported my claim that inpatient admission to the Hamilton General Hospital, in combination with positive findings of intracranial pathology, were sufficient to satisfy the 3 criteria, as they were objective markers and clinical predictors of prolonged recovery and poor outcome. I like to review the evolution of the CAT definition from Bill 59 in the 1990s to June 1st, 2016 too, in order to better understand the intention of the Ontario legislature. In my CAT case, I did this to highlight the fact that the shortcomings of the old reliance on the Glasgow Coma scale, which spurred on the intention of the Ontario legislature to introduce new measurement tools, such as Dr. Crouchman's Cauchy scale, in order to improve CAT determinations. Lastly, I look at other sources, such as the AMA guides, dictionaries, and the definition section of the schedule, to assist with my understanding of the meaning of the words at the heart of the interpretation dispute. For example, the interpretation of the word permanent is a common point of contention in the post-June 1st, 2016 decisions. The AMA Guide's 4th edition defines an impairment as permanent when it is unlikely to change substantially and by more than 3% in the next year with or without medical treatment. This definition was instrumental in the case applicant and RSA insurance, as it influenced the arbitrator to rule that the applicant's injuries were CAT. Therefore, it's important that the physician you retain to complete your medical legal lecture report uses this definition. So after we factor in the main objective of insurance law, the purpose of insurance contracts, and the principle of contra preferentum, and the intention of the Ontario legislature, we begin to see the rational basis for why an arbitrator would interpret section 3.115I in favor of my client. You can see here in the slide that as I continue to build my argument, I'm ensuring that it's aligned with the intention of the Ontario legislature as outlined in the 2011 superintendent's report. This approach I showed you formed the foundation that I built my arguments on, which persuaded the insurer to retract their initial denial of a CAT designation for my client, which increased her policy limits from $65,000 to $1 million. As you can see, I've summarized my argument in this slide. I then used the same argument to persuade the Financial Services Regulatory Authority of Ontario to amend the superintendent's guideline. So FSRAO has replaced the old superintendent's guideline with the new guideline on public hospitals and determination of catastrophic impairment. It interprets Clause 5I of Section 3.11 of the schedule as it applies to a public hospital named in the guideline. So it changes the interpretation of the automatic CAT definition. Now, all level 1 trauma centers, including the Hamilton General Hospital, are included in the public hospital list. It's a great start, but I don't think the change goes far enough. If you want to find out why I think the amendment doesn't go far enough, as well as more about the new catastrophic impairment criteria, then please feel free to look at my book, Catastrophic Impairment Law in Canada. In my book, I take a deep dive on the subject. I compare the different provincial regimes across the country and expose inconsistencies in proposed solutions to address inequities. Thank you very much. And if anybody has any questions, please feel free to email me at Andrew@RudderLawGroup.ca. I'll be happy to answer any questions that you have. Thank you.
Thank you very much. Thank you very much, Andrew, for that. Very detailed, and I did a lot of that work in practice. Still see a lot of catastrophic claims in mediation that, of course, are headed to the LAT. So still a very, very important area of law, and we appreciate that comment and your materials.